SwayamPrabha. Digital India. Educated India.
Hello friends, welcome to the class of Maritime Law. I am Dr. Ashutosh Acharya, Senior Assistant Professor, Law Center 2, Faculty of Law, University of Delhi. Now we will talk about the second part on the basic concepts of law of the sea. In the previous two lectures, that is historical development and the part 1 of basic concepts of law of the sea, we had seen the historical development as far as laws pertaining to law of the sea or laws pertaining to rules and regulations of sea are concerned. Here we will be talking about the territorial sea, the contiguous zone as well as EEZ of, let us say, islands which are more or less similar as far as, or you can say same as far as any other coastal state is concerned. An island also can have its own continental shelf, EEZ, contiguous zone or territorial waters. But at the same time we see different geographical structures coming into being, either attached to a state or individually. What happens when there is an archipelago? What happens when there is a strait, that is a sea lane or a sea gap between two different states? What happens when there is a geographically disadvantageous states? What are their rights and duties? So, there are different other types of geographically situated, constructed, structured areas which require our discussion as far as understanding of the law of the sea is concerned. And how do we take care of navigation of ships through these different routes? Whether a particular indentation is a bay or not, we will discuss that. Whether a particular sea gap between two states can be considered to be a strait. If it is a strait, what are the rules pertaining to navigation as far as the straits are concerned? What are the rules pertaining to navigation within the archipelago or from the archipelago is concerned? Whether it will be considered to be an internal water or not? How to draw baselines in the case of bays as well as archipelagos? Such are some pertinent questions that we will be answering in this module, that is in part 2 of the basic concepts of law of the sea. So, the learning objectives for today's lecture would be to learn to identify and draw baselines for bays and archipelago. What is archipelago? A cluster of island is known as archipelago. Different islands situated near to each other can form an archipelago. What is a bay? An indentation which may be in the shape of curvature, which is concave in nature and forms a sea, which may be having a closed opening. The inner part of the bay would have a larger portion of sea and the opening of the boundary or the coastline would be smaller as compared to the inner part. Whether all types of such diagrams or all such types of structures would constitute to be a bay or not, we will understand that also today. Second objective is to learn operation of jurisdiction in an archipelago. Thirdly, to learn the rights and duties of land-locked states and their access to sea. Friends, there are a number of states such as Afghanistan, Bhutan, Nepal and many others that does not have a coastal boundary or does not have a sea or does not have a coast altogether. How their rights can be protected, how they will be dealt as far as law of the sea and shipping regime is concerned. Do they not have any right to navigate? Can they have ships? Can they transact through sea routes? Also will be discussed in today's class. Fourthly, to learn the rights of access to marine resources by geographically disadvantaged states and landlocked states. There are certain states, for example, Germany, which can be considered to be a geographically disadvantaged states, for the very basic reason that it does possess a coastline, it does have a coast, but a smaller one, and that too a concave shaped, which makes it a little difficult for Germany to have a larger share or equitable share over North Sea. So, what happens in such scenario? Whether Germany can have equitable rights over North Sea as compared to the other states that are facing North Sea? So, what is the rule? What are the regulations and rules with respect to landlocked states and with respect to geographically disadvantaged states? These will be the areas with respect to which we will be discussing what is the present legal regime and what was the historical stance as far as these regimes are concerned. Our focus largely would be on United Nations Convention on Law of the Sea. What does the convention say as far as these 4 different regimes are concerned? Let us first talk about bays. If you look at bays, pre-1958 there are certain customary rules, and it says that there has to be close connection with the land. So, to claim a particular area of sea to be a bay, it must have a close connection with the land. Secondly, we have Anglo-Norwegian fisheries case, wherein 10 miles as maximum length was declared to be the closing lines. Now, let us understand through United Nations Convention of the Law of the Sea 1982, wherein under Article 10 it says that a bay is a well marked indentation whose penetration is in such proportion to the width of its mouth as to contain landlocked waters and constitute more than a mere curvature of the coast. An indentation shall not, however, be regarded as a bay unless its area is as large as or larger than that of the semicircle whose diameter is a line drawn across the mouth of that indentation. Let us, friends, understand through a diagrammatical representation. This, let us say, is a land portion, and let us say here we have sea water. This particular portion that we have drawn here, which is semicircle in nature, can be considered to be a bay. The diameter of the semicircle has to be more than the diameter of these 2 points. So, the diameter or the breadth of or the extent of the semicircle, the maximum strength, this has to be, this line has to be greater than the line that we see here. If such is the case, we can say that it may qualify to be a bay. If let us say the semicircle is of such a nature, can this be called as bay? The answer is no. So, to make a particular indentation or to qualify a particular indentation to be a bay, what do we need? First of all, we need that this diameter that we see here must be greater than the diameter that we have at the mouth or at the opening of the bay. That is the basic understanding. Secondly, this bay that we see here must have close connection with the land, which is customary in nature, of course. At the same time, if you look at the second clause, it says if the distance between the low water marks of the natural entrance points of a bay does not exceed 24 nautical miles. I repeat, if the distance between the low water marks of the natural entrance points of a bay does not exceed 24 nautical miles, a closing line may be drawn between these two low water marks and the waters enclosed thereby shall be considered as internal water. So, friends, let me draw this again. Let us say that this is our land area. If a state claims this particular portion to be a bay, then the distance between this point and this point should not be more than 24 nautical miles. As you can read again, if the distance between the low water marks of the natural entrance points, so this will consider to be a natural entrance point. Okay. Now, does not exceed 24 nautical miles. So, the distance does not exceed 24 nautical miles. A closing line may be drawn between these two low water marks. So, a closing line has been drawn between these two water marks, and the waters enclosed thereby shall be considered as internal water, and therefore, the water that falls within this region after drawing this particular line will be considered to be internal water. So, friends, if you remember in the last lecture we had already discussed and identified that once baseline has been drawn, the measurement starts from baseline, that is, it goes up to 12 nautical mile and 24 nautical mile and then 200 nautical mile. But what about the water that falls between the baseline and the coastline? Water that falls between the coastline and the baseline will be called as internal waters. So, water that falls as an area between coastline, baseline acting as internal water is considered equivalent to a territorial area. Similarly, if in a bay such a distance or at such distance, at such far longed distance, if the entrance point is considered to be the baseline, for example, let us understand through again a pictorial representation. Let us say this is the entrance point, and if a line is drawn here and is considered to be a bay, the repercussion would be that this particular point and this particular point, they can be joined, and this will be then called as baseline. So, if territorial water is then measured from here, all of which will be considered to be internal water. Having a bay gives benefit or advantage to the coastal state, as it gives more share or larger share of water to be coming within the sovereign rights of the coastal state. And therefore, there have been certain tussle, certain issues with respect to the matter that whether a particular indentation should qualify to be a bay or an indentation should not qualify to be bay, and therefore, Article 10 makes it crystal clear now what qualifies to be bay. So, the first requirement we have already identified, that we have to draw a line across the diameter and it should be more than this particular line that we have drawn here. Number 2, it must not exceed 24 nautical miles. The third clause will tell us clearly another requirement, and that is that where the distance between low water marks of the natural entrance points. So, the natural entrance points would be this as well as this, that is point A and point B. Then we see that where the distance between the low water marks of the natural entrance points of bay exceeds 24 nautical miles. If it exceeds 24 nautical miles, that is the distance between point A and point B, a straight baseline of 24 nautical miles shall be drawn within the bay in such a manner as to enclose the maximum area of water that is possible with a line of that length. So, therefore, friends, if this is less than 24 nautical miles, if this line between A and B is less than 24 nautical mile, then we will go with point A and B. If it is more than 24 nautical miles, then this will not be the baseline. Then we will identify the nearest point where we can get 24 nautical mile. So, let us say if the structure is of such a nature, let us say that this particular point A and B is more than 24 nautical mile, larger than 24 nautical mile, then we will search for a point here or any particular point here which will be less than or equal to 24 nautical mile. That particular line will then become our baseline, and we will join this particular point, that is maybe let us say this is point C and point C D, we will join these points C and D to the other points and continue with our baselines. So, as far as bays are concerned, there are two requirements. One is this diameter has to be taken care of, then 24 nautical mile requirement has to be taken care of. Once these are taken care of, we can say that it is qualifies to be a bay. But if any of these requirements are not fulfilled as per Article 10 of the United Nations Convention on Law of the Sea, then it will not qualify to be a bay. Further, friends, there have been historic bays. Apart from qualifying any particular bay to be a bay, historic bays have developed through customary practices. There have been problems faced by developing countries or decolonized states to qualify a particular bay, because developed states would be reluctant in allowing or identifying a particular intention to be a bay. For example, Park Bay, it can cite the practice of colonial and pre-colonial period. So, wherein a state has been decolonized, it can cite the practice of the period prior to decolonization and establish its case with respect to a historic bay. Examples of claims of historic bays are that Russia to Peter the Great Bay, Canada to Hudson Bay, and few other examples. There have been certain excessive claims as well, wherein certain intendations do not qualify to be a bay, but based on historic claims, certain states have designated to be a bay. For example, Gulf of Sidra in 1976, Libya drew a closing line stretching 296 miles, which is way ahead or way more than that of 24 nautical miles mentioned under Article 10 of the United Nations Convention on Law of the Sea. As it stretches 296 miles across the bay, it has been severely opposed by United States of America and other countries. Vital bays, vital for security, problematic claims. Bays bordered by more than one state. No international law per se has been there which clears or brings objectivity to the fact that what happens to the bays which are bordered by two or more than two states. Generally, they divide it equally. For example, we have Lough Foyle, that is between Ireland and UK, or Bay of Figure between France and Spain, which have been divided equally. Hence, we also have harbour works. What is a harbour work? A harbour work is an area wherein artificially harbours are created, where ships, boats and other kinds of vessels can harbour themselves. So, it is a kind of port where ships are moored or boats are moored, and when such structures are built up, they may also act as the point of baseline. Article 11 talks about harbour work, and it says that harbour work must be attached to the shore in case they are to be used as baselines, and in any case offshore installations and artificial islands shall not be considered as permanent harbour works. Islands, Article 121 talks about islands, and it says a naturally formed area of land surrounded by water which is above water at high tide. An island will have its own territorial sea. The contiguous zone, the exclusive economic zone and the continental shelf of an island are determined in accordance with the provisions of this convention applicable to other land territory. However, rocks which cannot sustain human habitation, economic life of their own shall have no EEZ or continental shelf. So, friends, islands have the same legal status as that of a state, and there can be an island state also. But if a state is having sovereignty or sovereign rights over a particular island, that particular state will have an extended territorial water, will have an extended EEZ or contiguous zone, and may also have continental shelf. So, islands are treated equivalent to states. At the same time, we have reefs. Reefs could serve as the baseline, and for ecological reasons, territorial sea should be measured from the outer limits of the reef. A reef is primarily an area which is ecologically sound, ecologically quite rich, and has green areas and marine rich life. If such reefs are present near to coastal regions, states can use those reefs in order to extend their territorial waters, in order to extend their EEZ or contiguous zone. So, reefs can be playing an important role as far as the extension of zones are concerned. So, therefore, reefs could serve as the baseline, and for ecological reasons, territorial sea should be measured from the outer limits of the reef, so that lagoon, which forms the main source of food for the inhabitants of atoll, has the status of internal waters. Apart from bays, friends, we have straits which should be taken into account as far as legal status and regulation is concerned. What is a strait? As you can see in the picture itself, we have taken the example of Strait of Gibraltar, which is between Africa and Europe. Here, the strait is an area which forms or which falls between two states, between two continents. It is a sea area which is quite narrow as far as its passage is concerned. Ships pass through straits, as it may be important for the ships to pass through these areas in order to avoid long routes, in order to avoid time, in order to save time, in order to save resources. It is sometimes deemed necessary and convenient to use these straits. There are many other straits such as Park Strait between India and Sri Lanka. How does the division takes place? Generally, friends, we see that straits are divided equally between the two opposite states. For example, India and Sri Lanka has a distance of 22 nautical miles as far as Park Strait is concerned, and they have divided equally. 11 nautical miles falls within the zone of India or territory of India, and rest of the 11 nautical miles falls within the territorial zone of Sri Lanka. Can other ships also use a strait as far as their navigation or navigational rights are concerned? We will discuss that. What does UNCLOS say? So, let us understand what is a strait first, and what issues can come into being, and how to resolve those issues by using the contemporary law, which is United Nations Convention on Law of the Sea. So, a strait is a narrow natural passage or arm of water connecting two larger bodies of water. As you could see that here you have Mediterranean Sea and here you have Atlantic Ocean. The Strait of Gibraltar connects two larger portions of sea and creates a passage, and therefore, it is a narrow natural passage or arm of water connecting two larger bodies of water. It is the legal status of waters constituting the strait and their use by international shipping, rather than any definition of a strait, that determines the rights of coastal and flag states. We may discuss an example through case law, that is Corfu Channel case, where a strait was used for navigation by a British ship, wherein we see that UK claimed the Corfu Channel to be a strait used for international navigation. Albania claimed that its sovereignty has been violated by the passage. That channel was not a strait used for international navigation, since it was only an alternative route used for local traffic between the Adriatic and Aegean seas. Well friends, let me give you a brief facts attached to the claims of United Kingdom and Albania. We see that UK ship was crossing through Corfu Channel, which falls within the strait, as I have already told you, between Adriatic and Aegean Sea. The claim of UK is that it is a route of international navigation, and under the right of freedom of navigation, all the ships have the right to pass or right to passage or free passage through Corfu Channel, whereas Albania has claimed in this case that the passage between the Adriatic and Aegean Sea, that is Corfu Channel, is not used for international navigation, and therefore, by entering into the Albanian waters, UK has violated the rights of Albania, that is by entering into the internal waters of Albania. It was further claimed that UK, when passing through Corfu Channel, had come into contact with certain underwater mines which were laid during the time of Second World War. Those mines were not removed, and therefore, basic question comes into being that whether Albania was under a duty to take care of the right of ships which comes within the domain of freedom of navigation, mare liberum, and therefore, there are two conflicting rights, that is for freedom of navigation. If freedom of navigation is upheld, and that too in the Corfu Channel, then in that scenario Albania was certainly under a duty to provide safe passage to any innocent ship that is crossing through Corfu Channel, and court upheld in favor of UK, looking into the fact that Corfu Channel has been used for a longer period of time for international navigation, and since it was used for international navigation, it was the duty of Albania to take care of Corfu Channel, that safe passage is provided for any kind of international navigation that is taking place through Corfu Channel, and therefore, court held that the decisive criterion is rather its geographical situation as connecting two parts of the high seas, and the fact of its being used for international navigation, noting its special importance to Greece by reason of traffic to and from the port of Corfu. Further, there has been tussle between major maritime states and the coastal states with conflicting claims of freedom of navigation and concerns of security respectively. Since we understand that a strait is a narrow passage, it will be very near to the coastlines of the concerned states, and therefore, states will have a legitimate security concern. How to settle those concerns against the freedom of navigation rights which lies with the ships that are navigating through those straits. So, these conflicting claims have been settled through a particular solution, and that solution is known as transit passage, that if any such straits are in existence and they are required for international navigation, then we can create transit passage. Now friends, what is a transit passage? The regime of transit passage has been discussed under Article 37 of United Nations Convention on Law of the Sea, and it says applied between one part of the high seas or an EEZ and another part of the high seas or an EEZ. So, it is nothing but a passage which will be considered for transit. No ship will be allowed to halt, and if there is an alternate route available where a ship is not bound to use, or it is not necessary for a ship to use that particular passage only, and there is alternate nearby route available, then the ships must avoid such transit passages. And therefore, there are three categories of straits that are excluded from the part of transit passage. There are three certain identified areas or situations, we can say, which do not qualify to be transit passage, or wherein straits will not be considered to be a transit passage. So, the first category of a strait through which, first category would be a category of straits through which there is a high seas route or a route through an EEZ of similar convenience with respect to its navigational and hydrographical characteristics. If there is a disturbed sea which is an alternative route, in that scenario also the strait can act as a transit passage. Otherwise, if there is an EEZ available, if there is a high seas available, that alternate route should be used, but it should be of convenience, it should not be of high inconvenience. Secondly, the straits formed by an island bordering the strait and its mainland, where a route of similar navigational and hydrographic convenience exists through the EEZ or high sea seaward of the island. And thirdly, the straits connecting an area of the high seas or an EEZ with the territorial sea of a third state. Now, what are the duties of ships and aircraft while they use a strait designated as transit passage, given under Article 39 of UNCLOS? Firstly, ships and aircraft, while exercising the right of transit passage, shall proceed without delay through or over the strait. As I said, stoppage, anchoring is restricted, is prohibited as far as those transit passages are concerned. So, a middle path has been taken as far as concerns of the territorial states are concerned, and also ships exercising their right or freedom of navigation is concerned. So, certain limitations that we see imposed upon ships and aircrafts are concerned say that it should proceed without delay through or over the strait. Secondly, should refrain from any threat or use of force against the sovereignty, territorial integrity or political independence of states bordering the strait, or in any other manner in violation of the principles of international law embodied in the Charter of the United Nations. Thirdly, refrain from any activities other than those incident to their normal modes of continuous and expeditious transit unless rendered necessary by force majeure or by distress. So, if there is an alternate route available, but the weather conditions of that particular alternate route is not sound enough, may create problem as far as navigation is concerned. In such scenario, only transit passage will be used. Lastly, comply with other relevant provisions of this part, and that would be that ships, secondly, in transit passage shall comply with generally accepted international regulations, procedures and practices for safety at sea, including the international regulations for preventing collisions at sea. The coastal states in transit passage could create sea lanes, could create certain navigational routes. It is only through those routes the navigating ship will be allowed to pass. It must not deviate in any manner as far as that particular route is concerned. If it deviates from that particular route, secondly, comply with generally accepted international regulations, procedures and practices for the prevention, reduction and control of pollution from ships. Aircraft in transit passage shall observe the rules of the air established by the International Civil Aviation Organization as they apply to civil aircraft. The state aircraft will normally comply with such safety measures and will at all times operate with due regard for the safety of navigation. At all times, monitor the radio frequency assigned by the competent internationally designated air traffic control authority or the appropriate international distress radio frequency. As far as research and survey activities are concerned in the transit passage, Article 40 says, during the transit passage, foreign ships including marine scientific research and hydrographic survey ships may not carry out any research or survey activities without the prior authorization of the states bordering these straits. Article 41, sea lanes and traffic separation schemes in straits used for international navigation. States bordering straits may designate sea lanes and prescribe traffic separation schemes for navigation in straits where necessary to promote the safe passage of ships. Further, such states may, when circumstances require and after giving due publicity thereto, substitute other sea lanes or traffic separation schemes for any sea lanes or traffic separation schemes previously designated or prescribed by them. So, we can see that sea lanes can be created, traffic rules can be created as far as the transit passage is concerned. Thirdly, such sea lanes and traffic separation schemes shall conform to generally accepted international regulations. Fourthly, before designating or substituting sea lanes or prescribing or substituting traffic separation schemes, states bordering straits shall refer proposals to the competent international organization with a view to their adoption. The organization may adopt only such sea lanes and traffic separation schemes as may be agreed with the states bordering the straits, after which the states may designate, prescribe or substitute them. Fifthly, in respect of a strait where sea lanes or traffic separation schemes through the waters of two or more states bordering the strait are being proposed, the states concerned shall operate in formulating proposals in consultation with the competent international organization, which could be in all or for all practical purposes International Maritime Organization. Sixthly, states bordering straits shall clearly indicate all sea lanes and traffic separation schemes designated or prescribed by them on charts to which due publicity shall be given. And when we say clearly demarcate, we mean to say longitude and latitudinal direction or earmarks must be placed. Seventhly, ships in transit passage shall respect applicable sea lanes and traffic separation schemes established in accordance with this article. Article 42 talks about laws and regulations of states bordering straits relating to transit passage. Subject to the provisions of this section, states bordering straits may adopt laws and regulations relating to transit passage through straits in respect of all or any of the following, that is, the safety of navigation and the regulation of maritime traffic, as we had already discussed under Article 41. Then the prevention, reduction and control of pollution by giving effect to applicable international regulations regarding the discharge of oil, oily waste and other noxious substances in the strait. So, sometimes when a ship passes through these straits, the ship might be in a need to discharge certain oil, certain material in order to balance and maintain the maneuvering part of the ship. And therefore, in such scenario, when a certain amount of water is released or when certain amount of discharge is released, pollution could be caused in sea water. In such scenarios, the state bordering the straits can make certain rules and regulations as far as such discharge aspect is concerned. With respect to fishing vessels, the prevention of fishing, including the stowage of fishing gear, then the loading or unloading of any commodity, currency or person in contravention of the customs, fiscal, immigration or sanitary laws and regulation of states bordering straits. So, these are the areas for which laws and regulations can be framed by the states bordering straits in transit passage. Secondly, as per Article 42, Article 43 talks about navigational and safety aids and other improvements and the prevention, reduction and control of pollution, wherein user states and states bordering strait should by agreement cooperate in the establishment and maintenance in a strait of necessary navigational and safety aids or other improvements in aid of international navigation and for the prevention, reduction and control of pollution from ships. Article 44 talks about duties of states bordering straits. States bordering straits shall not hamper transit passage and shall give appropriate publicity to any danger to navigation or overflight within or over the strait of which they have knowledge. There shall be no suspension of transit passage. So, if there is any danger within the strait as far as any transit passage is concerned, it must give due publicity and it must be informing to the ships that are passing through that transit passage. Not only to ships, but if any aircraft is to cross to that particular strait and there are any environmental concerns that should be informed to any air traffic or any airplane or any group of airplanes passing through that particular air route of the strait or transit passage. Suppose let us say there is creation of extra gravity due to coming into contact of heat wave and cold wave, and a buffer zone is created and it can adversely affect the airplanes passing through those transit passages, then the states bordering straits must inform the air traffic authorities to avoid such a route. And the same reasoning also goes as far as any ship crossing through or vessel crossing through transit passage is concerned. Now friends, let us talk about archipelagos. What is an archipelago? An archipelago is nothing but a group of islands. Let us say there are hundreds of islands, as you can see, cluster. So, all of this will be called as an archipelago. Now, how to draw a baseline, especially in the scenario when all of these group of islands constitute one single state. For example, West Indies, where there are cluster of islands and this group of islands form a particular country, or any other country where there is a group of island and it forms one single country. How will it have its own territorial water? How will it have its own exclusive economic zone? So, the simple rule pertaining to an archipelago would be that the outer lines of the outermost islands, that is, let us say these are the islands that we have. So, what we will do here is we will take the outermost points of these islands which are situated on the outermost points of an archipelago. So, this is an archipelago, we have taken into account the outermost points of the outer islands and we will join these points, and these points will be identified on the basis of low tidal point, and once they are all joined, a line would be created which will be known as baseline, and from this baseline we can calculate the territorial water or exclusive economic zone or our contiguous zone or continental shelf. Now, if you look at Article 46 of the United Nations Convention on Law of the Sea, it gives us the meaning of archipelagic states or archipelago. It says, for the purposes of this convention, archipelagic state means a state constituted wholly by one or more archipelagos and may include other islands. Archipelago means a group of islands including parts of islands. So, as we could see, we see that there are islands, single island, then there is another island, then this third, fourth, there are hundreds of islands, right. So, a particular island situated close to each other and they all forming one state will be called as archipelagic state. An archipelago would mean a group of islands including parts of islands, interconnecting waters and other natural features which are so closely interrelated that such islands, waters and other natural features form an intrinsic geographical, economic and political entity, or which historically have been regarded as such. So, somewhere down the line, political consideration, social consideration also could play a significant role as far as an archipelago to be considered an archipelagic state is concerned. Now, what about archipelagic baselines? Article 47 says, an archipelagic state may draw straight archipelagic baselines, as I had just drawn when we started discussing archipelagos. The state may draw straight archipelagic baselines joining the outermost points of the outermost island. So, as you could see, I had taken the outermost island and taken the outermost point of the outermost island, and drying reefs of the archipelago, provided that within such baselines are included the main islands and an area in which the ratio of the area of the water to the area of the land So, when we consider a particular region to be an archipelago and we try to draw a baseline, then we take into account the area of the water situated within the archipelagic or region or archipelagic state or archipelago and compare it with the area of the land including atolls, which should be or is between 1 to 1, that is the area of land equal to the area of water, and it should be compared to 9 to 1, that is area of water should be not more than 1:1 and not less than 1:9. So, the area of water and area of land could be equal, but in any case if the area of water is more than the area of land, then it should not be, or if it is more than that, then it will not qualify to be an archipelago. But if the area of water is 1 and the area of land is 9 times the water, then in such a scenario it should not be less than this particular ratio. So, when we talk about ratio, at max the ratio of water and land could be 1:1, but at least the ratio of water and land should not be less than 1:9 respectively, all right. And therefore, the length of such baselines shall not exceed 100 nautical miles. So, when we draw outer line of, we earmark these points, then we connect these points and we have drawn this outer line. If this is baseline, then it should not be more than 100 nautical miles. The maximum limit that is provided for the joining of points of the outer islands is 100 nautical mile, except that up to 3% of the total number of baselines enclosing any archipelago may exceed that length up to a maximum length of 125 nautical miles. So, in any case it should not cross 125 nautical miles. The drawing of such baselines shall not depart to any appreciable extent from the general configuration of the archipelago. If let us say there is a group of island and there is another island which is situated 50 nautical miles away from the group of islands, and there is same or similar cultural significance or the sovereignty is same as that of the archipelago, same political leader is there, same political party is there, it comes within the domain of same state, archipelagic state. The island will have its own separate territorial water or baseline or EEZ. The archipelagic state cannot stretch its baseline and go up to 50 nautical mile and include that whole that water within the baseline or consider it to be an internal water. So, for example, if there are these, this is archipelagic state and then you have an island here, it cannot stretch to such extent. This island will have a separate baseline, a separate territorial water and a separate contiguous zone EEZ. So, it must not depart to any appreciable extent from the general configuration of the archipelago. Such baselines shall not be drawn to and from low tide elevations, unless lighthouses or similar installations which are permanently above sea level have been built on them, or where a low tide elevation is situated wholly or partly at a distance not exceeding the breadth of the territorial sea from the nearest island. The system of such baselines shall not be applied by an archipelagic state in such a manner as to cut off from the high seas or EEZ of the territorial sea of another state. If a part of the archipelagic waters of an archipelagic state lies between two parts of an immediately adjacent neighboring state, existing rights and all other legitimate interests which the latter state has traditionally exercised in such waters, and all rights stipulated by agreement between those states shall continue and be respected. For the purposes of computing the ratio of water to land, paragraph 1, under paragraph 1, land areas may include waters lying within the fringing reefs of islands and atolls, including that part of a steep sided oceanic plateau which is enclosed or nearly enclosed by a chain of limestone islands and a drying reef lying on the perimeter of the plateau. The baselines drawn in accordance with this article shall be shown on charts of a scale or scales adequate for ascertaining their position. Alternatively, lists of geographical coordinates of points specifying the geodetic datum may be substituted. The legal status of archipelagic waters, of the airspace over archipelagic waters and of their bed and subsoil given under Article 49 says the sovereignty of an archipelagic state extends to the waters enclosed by archipelagic baselines drawn in accordance with Article 47 described as archipelagic waters regardless of their depth or distance from the coast. This sovereignty extends to the airspace over the archipelagic waters as well as to their bed and subsoil and the resources contained therein. Article 51 talks about existing agreements, traditional fishing rights and existing submarine cables. Without prejudice to Article 49, an archipelagic state shall respect existing agreements with other states and shall recognize traditional fishing rights and other legitimate activities of the immediately adjacent neighboring states in certain areas falling within archipelagic waters. The terms and conditions for the exercise of such rights and activities, including the nature, extent and areas to which they apply, shall at the request of any of the states concerned be regulated by bilateral agreements between them. Such rights shall not be transferred to or shared with third states or their nationals. An archipelagic state shall respect existing submarine cables laid by other states and passing through its waters without making a landfall. An archipelagic state shall permit the maintenance and replacement of such cables upon receiving due notice of their location in the intention to repair or replace them. As far as passage of ships through those archipelagic islands are concerned, Article 52 and 53 talk about the passage through archipelagic islands or archipelagic state. It says, subject to Article 53 and without prejudice to Article 50, ships of all states enjoy the right of innocent passage through archipelagic waters in accordance with Part 2 of Section 3. That is, ships do have right to passage as far as those cluster of islands are concerned. Ships can cross through those waters of islands or archipelago. The archipelagic state may, without discrimination in form and in fact among foreign ships, suspend temporarily in specified areas of its archipelagic waters the innocent passage. So, it can be suspended as far as innocent passage is concerned of foreign ship. If such suspension is essential for the protection of its security, such suspension shall take effect only after having been duly published. Article 53 talks about right of archipelagic sea lanes passage, and it says an archipelagic state may designate sea lanes and air routes thereabove suitable for the continuous and expeditious passage of foreign ships. So, there might be cluster of islands, but a particular sea lane will be created for any ship that is to cross the archipelagic state. It is the duty of the archipelagic state to identify and earmark such sea lanes through which navigation or freedom of navigation can take place. Therefore, all ships and aircraft enjoy the right of archipelagic sea lanes passage in such sea lanes and air routes. Archipelagic sea lanes passage means the exercise in accordance with this convention of the rights of navigation and overflight in the normal mode solely for the purpose of continuous expedition and unobstructed transit between one part of the high seas or an exclusive zone or another part of the high seas or an exclusive economic zone. Such sea lanes and air routes shall traverse the archipelagic waters and the adjacent territorial sea and shall include all normal passage routes used as routes for international navigation or overflight through or over archipelagic waters. Such sea lanes and air routes shall be defined by a series of continuous access lines from the entry points of passage routes to the exit points. So, these are certain rights of and duties as far as archipelagic states are concerned. Then we have landlocked and geographically disadvantaged states. Friends, out of the world's total number of states, around 42 states have no sea coast. Moreover, many of them lack natural land resources and fall amongst world's poorest countries. Additionally, there are states which are geographically disadvantageous states due to the structure of their coastline or unavailability of resources in sea adjacent to them. Example could be Germany, Singapore, Democratic Republic of Congo, Jamaica, Nauru, Tanzania. Thus, three main questions arise with respect to their claims under the regime of law of the sea: the right of navigation, right of landlocked state ship to navigate to sea, whether landlocked states can have their own ships, how do they navigate, access to marine resources, access to landlocked states to the sea. They have the right to innocent passage as far as customary right is concerned under Article 17 of UNCLOS also is concerned. At the same time, Article 69 talks about right of landlocked states, and it says landlocked states shall have the right to participate on an equitable basis in the exploitation of an appropriate part of the surplus of the living resources of the EEZ of coastal states of the same subregion or region, taking into account the relevant economic and geographical circumstances of all the states concerned and in conformity with the provisions of this article. The terms and modalities of such participation shall be established by the states concerned through bilateral, sub-regional or regional agreements taking into account their inter alia. So, if Nepal is a landlocked state, Bhutan is a landlocked state, it could use the sea by entering into bilateral agreements with China or with India or with Bangladesh or Myanmar. The need to avoid effects detrimental to fishing communities or fishing industries of the coastal state. The extent to which the landlocked state, in accordance with the provisions of this article, is participating or is entitled to participate under existing bilateral, sub-regional or regional agreements in the exploitation of living resources of the EEZ of coastal state. The extent to which other landlocked states and geographically disadvantaged states are participating in the exploitation of the living resources of the EEZ of coastal state and the consequent need to avoid a particular burden for any single coastal state or part of it. The nutritional needs of the population of the respective states. So, such things are to be taken into account while they enter into bilateral or other kind of agreements. When the harvesting capacity of a coastal state approaches a point which would enable it to harvest the entire allowable catch of the living resources, and in such a scenario the excess could be supplied to the landlocked states or geographically disadvantageous states. Developed landlocked states shall, under the provisions of this article, be entitled to participate in the exploitation of living resources only in EEZ of developed coastal states of the same subregion or region, having regard to the extent to which the coastal state, in giving access to other states to the living resources of its EEZ, has taken into account the need to minimize detrimental effects on fishing communities and economic dislocation in the states whose nationals have habitually fished in the zone. The above provisions are without prejudice to arrangements agreed upon in subregions or regions where the coastal states may grant to landlocked states of the same subregion or region equal or preferential rights for the exploitation of the living resources in EEZ. So, largely it is based on agreement as far as the rights of landlocked and geographically disadvantaged states are concerned. Part 10 talks about right of access to landlocked states to and from the sea and freedom of transit. As far as landlocked states are concerned, Article 124 says that landlocked states means a state has no sea coast, a transit state would mean a state with or without sea coast, traffic in transit would mean transit of persons, baggage, goods and means of transport across the territory of one or more transit states. Means of transport would mean railway, rolling stock, sea, lake, river, craft and road vehicles where local conditions so require, porters and pack animals. Article 125 talks about right of access to and from the sea and freedom of transit. So, landlocked states also carry similar kind of rights as far as transit passage etc. is concerned, and we have already discussed that particular aspect. And we see that when harvesting capacity or when excess is available, must or it can be supplied to the landlocked or geographically disadvantaged states. So, provisions have been made under United Nations Convention of Law of the Sea, where interest of the landlocked and geographically disadvantaged states have been taken into account under Article 124, 125, 70 and some other provisions. So, with this we conclude that we have discussed the legal regime pertaining to archipelago, bays, straits and geographically disadvantaged states in addition to landlocked states. And with this I conclude this module and lecture. Thank you so much. Namaskar.